Welcome to the world of decoding the conflict mindset. This is one episode that you will not want to miss. Jeff sheds a lot of insight, a lot of learned experience to the world of dispute resolution. Whether you are a lawyer advocate, a lawyer mediator, a non-lawyer mediator, or simply a consumer of dispute resolution services. Listen and learn. He has a lot to offer. Welcome, Jeffrey.
Welcome. Thank you, Debra. It's delighted to be here. Please call me Jeff.
Yeah, very good. I will do that then. Great. So, Jeffrey, you have such an illustrious background. It's just pretty incredible in terms of, all the things that you've done and the education you've achieved. And I know you've got some speaking engagements coming up. And I would like to ask you if there were, one thing that stands out in your background, what would that be in terms of your education, your experience?
I would say I have wonderful parents who brought me up with a lot of love and good values and set me on my course in life.
That's amazing. Well, we all have a story, and oftentimes those early childhood stories are really key to how we show up as adults, right?
That's right.
Yeah, those influences, absolutely. And I know that you're going to influence our listeners and viewers today as well, but I do want to tell them a little bit more about your background. Okay. So you do independent mediation now through Jeff Kichaven Commercial Mediation. You've been doing that for about 12 years?
I've had this company for about 12 years. That's right.
Great. And you're also with JAMS, and tell our listeners and viewers what JAMS stands for.
I was with JAMS in 2007 and 2008. It doesn't stand for anything anymore. It used to be Judicial Arbitration and Mediation Services. Now I think it's just JAMS.
JAMS.
And it's a nationwide, very international, really, I think, provider of mediation, arbitration, and related services.
I thought I'd heard that too, that it just has lost, what it really stood for before. But you've also been a partner and counsel in a couple of different law firms throughout your career as well, right?
That's right, here in Los Angeles.
Yeah. But I think most impressively for me anyway, is that you were cum laude at Harvard Law School.
Thank you. Yes, class of 1980.
Yes, I mean, that must have been quite the experience.
It, for a guy who'd not really spent more than a couple of weeks outside of California his whole life before then, it was quite an experience to be in the snowy Northeast. Different culture, different climate, learned a lot.
Yeah, well, otherwise you really did spend your life in California because you went to the University of Berkeley, or California, Berkeley, and was in the Phi Beta Kappa.
Thank you. That's right. Class of 1977. I was an economics major.
Wow. I'm sure that served you well in your dispute resolution career.
Yeah, on good days, yes.
Very good. But some other things too, and I'm going to take a look at my list here. You were awarded as best lawyer in the Best Mediation Lawyers in Los Angeles in 2015, so just a few years ago. You also received the Roy H. Aaron Award for being outstanding board member for the Center for Civic Mediation, and also received a special award for excellence in mediation by the Asian Pacific American Dispute Resolution Center in 2010. And we're the California Lawyer Attorney of the Year in ADR in 2006. And
all correct.
You didn't stop there. You've been an 8-time honoree in California's top neutrals out of the Los Angeles and San Francisco Daily Journal. Boy, you've been busy.
Well, I love mediating, and I've been doing it now for 25 years. And it's always very flattering, and it's a tremendous honor to be recognized by your peers and the lawyers with whom I work. It's a great honor.
Well, that's absolutely fascinating. That's wonderful. It's wonderful. Jeff, I'm curious, one of the ways I got to meet you, I've heard your name for years, but, when we pivoted so significantly into the virtual world of online dispute resolution, I recall that you wrote an article saying, I don't know about this. Elaborate a little bit more on your article.
Well, shortly after the lockdown, I did a survey of lawyers with whom I have worked and lawyers whom I know. all across the country to see how they felt about the transition to online mediation. And there was a fair amount of skepticism and a fair amount of resistance.
Mhm.
And change comes hard to a lot of people. And you may remember last spring, nobody knew which end was up and which end was down. Society was in a very chaotic state,
Mhm.
very anxious
Mhm.
state when the lockdowns began. And lawyers were cautious and reluctant, skittish. And I think what we've seen over the last year is that reluctance and the anxiety has largely melted away. People have become extremely accustomed to conducting most of their lives, really, online. And so we've adapted, we've learned a lot of things we never thought we would learn. And people are now generally quite comfortable conducting mediations on Zoom as they are comfortable conducting so much of the rest of their lives online on one of these platforms or another.
Right. It was a rapid transition. Some of us were already there. Some of us had never been there. And I know I just read an article the other day that was basically talking about from boardroom to living room, and how, the virtual platform is really governing our world in oh so many ways.
Mhm.
Yep. Yep. Yeah. So I'm curious then, one of the big topics that you address a lot in your writings, and I'm sure in your speaking, is around confidentiality. And that raises a lot of concerns for people going into the online platform. And so, um, you know, I'll let you decide where you want to start with that, but there's several questions I have for you around confidentiality.
Well, why don't you start with a particular question? There's so many different areas where we can focus.
Okay, so one of the questions I have that I think that maybe a lot of people may not really well understand is the critical role of confidentiality in mediation. And so say a little bit about that before we get into some of the rules that govern confidentiality.
So there's at least three ways in which people use the term confidentiality in mediation. One is in a caucusing model of mediation, where the mediator will speak to, for example, the plaintiff's side and then go down the hall and speak to the defense side. Many mediators will promise not to repeat to one side what the other side has told them. So if the plaintiff tells you something and says, keep this in confidence, or perhaps the understanding is everything will be kept in confidence, won't be repeated down at the other end of the hall. That's one way in which people discuss confidentiality in mediation. Another way is in terms of the rules of evidence, formal rules of evidence, which govern admissibility of evidence in courts and whether material is subject to discovery through depositions or interrogatories. So sometimes we use the word confidentiality in mediation to refer to whether or not what happens in a mediation can be admissible, can be presented, introduced in evidence, and made admissible in evidence in some later court or arbitration proceeding. So that's the second sense. The third sense in which people use the term confidentiality is in a broader, should we say, more public sense. Can you go out of a mediation and discuss what happened with your bartender or your friends at the gym or newspaper reporter or anybody else? So there's at least three senses in which people use the term confidentiality in connection with mediation. Whether it actually is that important or not is an empirical question, and there's really not very much evidence to support the assertion that anybody cares about it. For example, you see there are many adjacent states that have different levels of statutory confidentiality and different levels of different standards by which what happens in mediation either can or can not be introduced in evidence or made subject to discovery. And for example, New York has almost no statutory protection for the privileged or confidential nature of what's said in mediation. And New Jersey, on the other hand, right across the Hudson River has the Uniform Mediation Act, which is a much more robust protection of the privileged nature of mediation. You would think that if mediation confidentiality, at least in the sense of admissibility and evidence, made that much difference to people, those bright, sharp New Yorkers would go across the river to Jersey City and conduct their mediations there. But they don't. I asked the officers of, I believe it's called the New Jersey Professional Mediation Association. It's their trade association for mediators. And I asked them, do you guys engage in promoting a kind of mediation tourism and encouraging New Yorkers to come across the river? And they said, no. They acted like that was the strangest question they'd ever been asked. And I asked many New York lawyers, do you ever consider going across to New Jersey where there's greater statutory protection for the privileged nature of mediation communications? Never even enters their mind. So you must question, is it that important? It's not that hard to figure this out. New Yorkers do respond well to other statutes and laws in New Jersey when they're material. For example, in Jersey City, I understand the sales tax there is 3.9%, and in Manhattan, the sales tax is over 9%. And people I know who are in that area tell me that Jersey City has quite a robust retail economy. New Yorkers go there. So when there are laws of New Jersey that actually make a difference to people, New Yorkers respond. The fact that New Yorkers do not respond to New Jersey's more protective mediation privilege law, well, one must really ask, at least in that sense, what difference does it really make?
So would you say, one thing I'm gleaning from this then is confidentiality more important to the parties in mediation, or and less important to the lawyers or mediators in mediation?
Lawyers have a fiduciary obligation to serve their client's interest. If the New York lawyers thought it served their client's interest to have the New Jersey Uniform Mediation Act apply, it's pretty simple to get across the Hudson River and go to Jersey City.
Okay. So I know, at least in my line of training, and when I train mediators, having the parties engage in a written statement of confidentiality, consent to mediate kind of agreement is important going into the process. Am I hearing you then that is not so essential?
I would ask you what the evidence is to support that.
Okay. I guess it's more of models of practice then, because that's how I was trained. I never even thought to question it.
It's an assumption.
Okay.
I don't think there's evidence for it, at least not in the sense of being able to introduce things in evidence.
Okay. So, you mentioned the Uniform Mediation Act and or what's called the UMA. And so that I know has been around for a long time. I don't even remember when that got implemented, and you could probably tell us that. But I understand, that not a lot of states in the United States have really embraced that.
That's right. I think it's 11 states and the District of Columbia. So the Uniform Mediation Act really has not succeeded in creating uniformity. If you think about other uniform statutes, probably most prominently the Uniform Commercial Code, I think that's the law everywhere in the country, with some minor variations from state to state, as I understand it. That really has achieved the goal of uniformity. So I would say that the legislatures of our country must not think that the level of privilege provided by the Uniform Mediation Act is very important either.
So what rules do exist that address confidentiality, and particularly now that we're going to the online, virtual platform?
Well, it's a very interesting question, because in online mediations, you might have participants in many different states. And so the question arises, by operation of law, which state's privilege or confidentiality law applies to that mediation? It's not obvious, and it's not as obvious as it would be if, for example, everybody were sitting in a conference room in one particular physical place. One might assume that the law of that place would apply ordinarily to that mediation. But even that's not so, Deborah. If the privileged or confidential nature of an in-person mediation is tested in some other state, the courts of that other state do have some discretion to apply the law of that state, the forum state, rather than the law of where the mediation took place. And if the law of the forum state is less protective, then there are some courts that have defeated people's expectations of confidentiality based on where the mediation took place, and even based on confidentiality agreements that they've signed. The first case in that regard, a case called Larson versus Larson, that was pending in the federal court in Wyoming. The participants there had a mediation, but they didn't have it in Wyoming. They had it in Denver, Colorado. Colorado law is pretty robust in protecting the privileged, confidential nature of mediations, and Wyoming law is not. There was a dispute. They had a term sheet. They had trouble finalizing the settlement agreement. So they had to go back to the court in Wyoming to try to get that, one of the sides tried to get that settlement agreement enforced as a judgment of the court in Wyoming. And they wanted to obtain evidence of what the other side, there was a family business dispute, but their brother had evidence of what their brother had used as evidence at the Colorado mediation. He'd used a PowerPoint, and his siblings wanted to get hold of that and use it in evidence against him in the Wyoming proceeding. Now, they were all physically present in Colorado, and they had signed a confidentiality agreement providing that Colorado law would apply. But the magistrate judge in Wyoming, based on public policy grounds, the general interests of Wyoming citizens, disregarded both Colorado law and the Colorado confidentiality agreement, applied Wyoming law, ordered the PowerPoint produced. The case went up to the 10th Circuit, and the 10th Circuit affirmed on a very generous standard of review, abuse of discretion, and said the magistrate judge did not abuse her discretion when she ordered that PowerPoint produced. So if the confidentiality of your mediation is ever tested in Wyoming, all bets are off. And I know that doesn't really concern a lot of people because Wyoming is not a commercial center, right? It's a beautiful place. It has wonderful people, great natural resources, physical beauty, but it doesn't have that many people. And the chance of your mediation having its privileged nature tested in Wyoming is kind of remote. But let me tell you, the same thing could easily happen in New York. New York is our most important commercial state. And there are recent cases from December 2020 in New York where New York courts basically did the same thing. There was one case called General Electric versus APR. This case pending in New York, and they were testing the confidentiality of an Illinois mediation in a later proceeding in New York. Illinois has the Uniform Mediation Act, and the parties to the Illinois mediation also had a confidentiality agreement. The judge in New York basically disregarded Illinois law, applied New York law, disregarded the parties' confidentiality agreement, and found that then overruled the objections to discovery based on mediation privilege. Now, there were other objections based on the attorney-client privilege and the work product doctrine. Those objections were sustained. But nonetheless, the important point for us is that that court in New York, General Electric versus APR, disregarded the more protective law of another state. There's another case from New York, December 2020, Accent Delight versus Sotheby's. And in that case, I believe all the mediations took place in New York there, but they had a confidentiality agreement. Sotheby's Accent Delight was testing the confidentiality of a previous mediation to which Sotheby's had been a party. And in that case, the court disregarded any confidentiality agreement or law to the contrary and said under New York law, which does not really protect mediation confidentiality or privilege very much at all, production could be ordered, but only if a standard of heightened need were satisfied. In layman's terms, that the parties really, 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 really needed that evidence and couldn't get it from anywhere else. So while the court said production could be ordered if a standard of heightened need is met, the court found that in that case, the standard was not met. And so the court did not order the discovery to take place. Again, the important thing, though, is that if the standard had been met, this judge would have had no qualms about ordering the production. So this really calls into question whether mediators or lawyers ought to be making airtight confidentiality promises to people. Mm-hmm. Because, you see, judges have a natural inclination to want this material produced if it's relevant to the issues before them. And that's not a bad thing, because we want courts to get decisions right. Courts make decisions that are very important, have significant impacts on people's lives, and we want those decisions to be correct. That's why we have what's called the basic rule of evidence, and it's the basic rule of evidence everywhere, that all relevant evidence is admissible. And we want the relevant evidence to get before the triers of fact, judges and juries, so they can get things right. Privileges and confidentiality rules interfere with that, because a privilege is you invoke a privilege only when the evidence is relevant. If the evidence is not relevant, you never get to these other considerations. So if you meet a test of relevance and then you interpose an objection based on privilege or confidentiality statute, if that objection is sustained, you're depriving courts of relevant evidence and hampering their ability to get things right. That's why in evidence law, you have the famous phrasing by Professor Wigmore in his famous evidence treatise that privileges are supposed to be narrowly construed, no more broadly than necessary to effectuate their purpose, because they do frustrate the search for truth every time they're involved. So there's this tension here between relevance, we want all relevant evidence to get presented to courts, and privilege. There are certain other public policy reasons like attorney-client privilege, priest-penitent privilege, doctor-patient privilege. And we want to promote candor in those other relationships, and so there are privileges there. So when you make an airtight promise of confidentiality, knowing that a court in New York or a court in Wyoming may just disregard the law of a different state and apply the law of its own state, how can you really make an airtight confidentiality promise? Even if a court doesn't take this territoriality approach and decides to apply a different standard, which is the law of the state with the most significant relationship to the communications that took place, and that's the more common conflict of law, choice of law standard when it comes to picking evidence laws. You apply the evidence law, a privilege or confidentiality law of the state with the most significant relationship to the communications that took place. Well, that becomes kind of a metaphysical question in the age of online mediation, because you might be in one state and I might be in another state and somebody else might be in a third state, and people are going to different states because they like the different lockdown standards or lack of lockdown standards in different cases better. So it's not uncommon to have people fanned out now in different states. And so if the question of which state's law applies to this mediation is presented to a judge who has an incentive to get the relevant evidence before them has an incentive to apply the law of the state with the least protective privilege or confidentiality law, right? Because their incentive is to get the relevant evidence before them. And if that decision is appealed, the appeal will generally be considered on a very generous, or shall we say forgiving, standard of review, abuse of discretion. It's very hard to prove that a trial court judge abused discretion. And those decisions, if the decision is to compel production, that decision is likely to be affirmed. So there's a real question for mediators in terms of, should we be making airtight confidentiality promises? Because what is in so many of these confidentiality agreements are promises that look like they're worldwide and absolutely airtight. And the mediators and lawyers making those promises don't have the power to keep them. The power to keep or break those promises is in the hands of judges in later cases who will be reviewing requests to compel production of evidence that was generated in those mediations.
What you said before, Jeff, really piqued my interest in the sense of it sounds like, the parties to mediation really have some discretion as far as when people come together from different states and so forth to choose sort of willy-nilly, which state or laws are they going to go by, and particularly as it applies to confidentiality. And you've already given examples about how, in a way, I guess, lax Wyoming is about confidentiality as opposed to some other states like Colorado, just across the state line. And so I'm curious then, as far as, particularly our mediator lawyer advocates who might be listening, as far as, I'm going to put this question out there. From my perspective as a psychologist mediator, I address confidentiality in the sense of creating psychological safety within the mediation so that people feel comfortable enough to really go where they need to go to share information that will help bring resolution. And that may be still true in many other kinds of mediations. But when I'm hearing, when there are more legal issues at stake, that they're like it's up for a crapshoot. and so in that regard, I mean, can parties come to some agreement about which state they're going to abide by up front, or is that just sort of depends on what happens?
They can try, and they might want to, and it requires a thoughtful approach, not a reflexive approach, because to the extent that there may be some choices as to what state's law you wish to apply, you have to ask yourself, which state's law is better for my client? A higher degree of confidentiality may not always benefit your client. A lower degree of confidentiality may sometimes benefit your client. And the most interesting case that I have found on that case called Facebook versus Connect You, which is a Ninth Circuit case from 2011, and it involved the famous battle between Mark Zuckerberg and the Winklevoss twins. The subject of the social network. So to recap the facts briefly, at a certain point, Mark Zuckerberg bought from the Winklevoss twins their shares in Facebook. The twins came to believe that Mark Zuckerberg had defrauded them in the valuation of the shares, and so they sued. They had a mediation, and they came to an agreement, and the Winklevoss twins then came to believe that Zuckerberg had defrauded them again, this time at the mediation, and again with respect to the value of the Facebook shares. So the Winklevoss twins they applied to the court to unwind or rescind the settlement agreement that they had with Mark Zuckerberg. The Ninth Circuit took a look at it and said, well, under ordinary circumstances, if Federal Rule of Evidence 408 were applied to this, you would be able to introduce the evidence of what Zuckerberg said at the mediation to try to prove a contract-based defense to the enforcement of the mediated settlement agreement. And the contract-based defenses in law generally are fraud, mistake, and duress. So under Federal Rule of Evidence 408, you're prohibited from introducing in evidence offers and demands that are made in any settlement negotiation, but only if you're trying to use them to prove the strength or weakness of the claim being negotiated. For collateral purposes, such as proving a contract-based defense to a mediated settlement agreement, Rule 408 ordinarily would allow you to do that. But the Ninth Circuit, Judge Kaczynski noted, at the beginning of the mediation, the Winklevoss twins and Zuckerberg had signed one of these airtight confidentiality agreements. We will never attempt to use evidence of anything said or done in this mediation against each other or anybody else, anywhere, anytime, any place. You know how these go. So the Ninth Circuit said, look, you signed a contract in which you promised not to use evidence for any purpose. And guess what? We're going to hold you to your word. So in that case, a lesser standard of confidentiality would have benefited the Winklevoss twins. They at least would have been able to get a hearing on the merits with respect to their claim that Zuckerberg had defrauded them a second time. So what sometimes happens with these mediation confidentiality agreements, Debra, is that, as happened with the Winklevoss twins, you are forfeiting rights that the relevant legislature wished you to have. Congress, when it enacted Federal Rule of Evidence 408, wished for litigants to be able to use evidence that came out of settlement negotiations, any kind of settlement negotiation, for some of these collateral purposes. When the Winklevoss twins signed that confidentiality agreement, they and Zuckerberg forfeited certain rights that Congress intended them to have. So query, when you have people sign a mediation confidentiality agreement, are you intending them to forfeit rights that legislatures intended them to have? Are you telling them that that's what they're doing?
Wow.
Those are serious questions.
Mm-hmm.
If you think you're going into a mediation at an information disadvantage, you may not want such a high degree of confidentiality to obtain in that mediation, because you might have a concern that you will be defrauded, and you might want to be able to do something about that. It might not happen in every case, but the real point is to approach the subject of confidentiality thoughtfully and not reflexively. In your situation, the family law situations where I really don't practice, circumstances might be totally different, and different rules and standards might apply. I know in so many cases, people are not represented by lawyers. So that creates a difference. And I don't know whether, if you are a psychotherapist, whether it's psychotherapist-patient privilege obtains or applies in your mediation as well. I just don't know.
Yeah, I mean, absolutely. I mean, in terms of my patient-doctor relationship, there are limits. Like if I get called into court, there are limits about what I can and cannot say. And that's true as a mediator as well. And so I have seen cases here in San Diego County where I mostly practice, although that's expanding in today's world, but where judges have compelled mediators or psychotherapists to turn over their work. Now, if I've been appointed by court, or if I'm an expert witness in a child custody evaluation, it's very clear in my agreement up front that any information I have is for use within the court, since it is a
Right.
court role. Yeah. I guess going back to our mediation, well, actually, I do a lot of workplace mediation too, and oftentimes in what I do, there are not lawyers involved either. And but even there, I try to say, well, because there's usually, not always, but frequently an ongoing relationship, that then having some degree of confidentiality so that what happens in the mediation room is not broadcasted out to coworkers. Then we do, I do engage parties into a confidentiality agreement. But I think, going back to that broader sense.
Excuse me, Debra, remember I said there were at least three senses in which the word confidentiality or privilege is used. And what you're talking about is we won't talk to others in the workplace, friends and neighbors, people in the community. That's different than admissibility in evidence.
Yes.
And people in those terms, those kinds of provisions can be controversial as well, right? In products liability cases, in Me Too cases where famous people would have these kinds of confidentiality agreements and query, did it create a license for them to engage in further misconduct? The products liability, pharmaceutical cases, and those arenas, those kinds of provisions are controversial as well.
Yeah, it's sort of a quagmire from what I'm gathering. And like you say, I really appreciate the fact that you distinguish the three types of confidentiality that generally get applied. And so it does matter which kind of setting that you're in. And I guess I'm wondering, would it behoove the mediator, particularly more in the world that you're talking about, to address it, but is it the responsibility of the mediator or the lawyer advocate with his or her party to address the issue or the topic of confidentiality, and to also then, as we talk about more, crossover in state lines and even international lines, that depending upon where, if this does not resolve and depending upon where this goes, is that confidentiality that we've agreed to may not be upheld?
I think it's really up to the lawyer,
Okay.
where there are lawyers. It's up to the lawyer to discuss this candidly with their clients. Lawyers have an ethical duty of competence. They have to know the law. They have ethical duties of communication, clear communication, and candid communication, so that clients can make appropriate choices in whatever circumstances they have. So here's how I look at it. Making representations as to mediation confidentiality or privilege is really a kind of legal advice as to how candid your client should or should not be in the mediation. You should or should not be this candid or this secretive or that secretive in the mediation, because this is what might happen if you say X, Y, and Z. So it's really a matter of the lawyer advising the client on how candid to be, based on the lawyer informing themselves as to what the confidentiality rules are, or what confidentiality or privilege rules a court may apply to that mediation, given that you really have no idea where the confidentiality of your mediation may be tested, no matter where your mediation actually takes place. And in the online environment, who really knows where the mediation is taking place?
That's absolutely true. That's absolutely true. On that note, and I thank you for clarifying that it's really the role of the lawyer advocate then to prepare his client. Is there a responsibility on the part of the mediator to at least have that in the pre-mediation, the preparation stage for the mediation, to address that concept with the lawyer advocates representing the parties?
I think it's fair game for mediators to ask lawyers uh, if they have thought about the concept of confidentiality, particularly in the online environment, and if they want to have an agreement as to confidentiality, they should.
Okay.
And they should create one the same way they create any other contract they would advise their client to sign, carefully and customized to fit the particular circumstances.
Well, I can see that this is an area that's going to probably deserve and warrant some more attention, because I think, at least in my mind, it was much clearer before we went into the online world. But as you've said, and I've referenced, that as we're starting to cross state lines, given our ability to work anywhere, that these issues are going to come up more and more. And so for some of us, our traditional notions of mediation and confidentiality may not apply in the same sense that they did before.
Yes, well, look at it this way, Deborah. Let's say you, as mediator, prepare a confidentiality agreement that goes way beyond saying that there's some state or federal law, whatever that applicable law is, will apply. Let's say the mediator prepares a confidentiality agreement that goes to discussing with others in the workplace or the community or the press or anybody else. Let's say that's the mediator's agreement. The legislature did not take the right to talk to people in the workplace or the press away from you as a part of the price of admission to mediation. Okay. So the legislature must think it's okay that people have those rights. So then if you put it in your confidentiality agreement as a mediator, what you're saying is that you are conditioning your willingness to serve as a mediator on people forfeiting rights that the legislature intended them to have, or at least did not take away from them. And most every legislature has considered the subject and enacted an evidence code of one type or another. I don't think it's right for mediators to condition service on people forfeiting rights which legislatures wanted them to have, particularly when the mediator isn't explaining to people that that's what's happening and why. I just don't think that's right.
Yeah.
Again, if the people themselves want to enter into that kind of an agreement, they should have every right to do so. And in some cases they will, and in some cases, plaintiffs, and particularly in certain kinds of cases, we mentioned before, may not want that. And even in some cases, it's conceivable defendants may not want that.
Well, as we have already commented, I'm sure that this will be a topic that will warrant further discussion and exploration as we move
Yeah.
forward. Because it's the more we talk, the more complicated it seems. And again, people are going to think differently about it depending upon which jurisdiction they are. And and so, yeah, something to sort through. But Jeff, before we conclude today, I want to bring out, I know a project you're very passionate about, and something that started, about a year or so ago. And so share with our viewers and listeners about your program, We'll Work for Food project.
Oh, yes. Every Thursday morning, 8 o'clock Pacific time, 11 o'clock Eastern time, the Will Work for Food project presents the New Possibilities Hour, which is designed to help lawyers and mediators and arbitrators become better at what they do, better informed about negotiation and certain areas of the law, how to litigate and to negotiate and settle certain kinds of cases.
Mm-hmm.
Natalie Armstrong-Mouton in France founded the Will Work for Food project shortly after the lockdown began. Natalie is a consultant to mediators and arbitrators worldwide about business development and marketing practices. She's written books. She's a tremendous international expert on the subject. And she was kind enough to invite me on board to work on this project with her. And then at the beginning of this year, Jean Lawler, another very fine mediator here in Los Angeles, she focuses primarily in the insurance coverage arena, an area where I do a lot of cases as well. Jean joined our team. And every Thursday, we have wonderful, wonderful speakers. We've had defense lawyers, leaders of defense organizations come and talk to us about how mediation could be better from the defense side of the aisle. We've had the president of the Consumer Attorneys of California come and talk to us about how mediation can be better from the plaintiff's side of the aisle. We've had various diversity-related programs. We've had past presidents of the National Asian Pacific American Bar Association. We've had leading people from other communities. Professor David Wilkins from Harvard Law School talking to us about what mediators need to know about big law, which is a principal area of David's research. We had Dee Dee Litvin from the General Counsel's Office at Merck talking to us about vaccines and what are the legal issues, the legal rules that govern vaccines, and what kinds of litigation and settlements might we see coming out of vaccines. We've had Jim Pooley, who's a national leader on trade secrets, talk to us about some of the psychology of mediating and settling trade secrets cases. We've had jury consultants talking to us about what jury trials may or may not look like in 2021 and going forward. We have people talking, Dean Song Richardson from UC Irvine School of Law talk to us about implicit bias and racial anxiety and what to do about those. So we've had a wide variety of speakers from many different perspectives on many different topics, and it's all to raise money for food banks. There's no charge for these great webinars, Debra. Rather, we ask people to contribute to food banks to fight food insecurity if they like what they see. And our audiences in the ADR and mediation, arbitration, and litigation communities have been so generous. It's unbelievable. Would you believe, Debra, our audiences so far have contributed over $85,000 to food banks worldwide to fight food insecurity. And the number goes up every week, and it chokes me up more and more to realize how very generous our communities are. So thank you for bringing up that subject. Thank you for giving me the opportunity to mention it. And we have great topics coming up. Every speaker gets to designate a food bank that's
Oh,
important to them. And people, if they are able, have been so generous in donating to the food banks mentioned and promoted by our speakers, as well as food banks in their home communities. We have people from Africa, from Asia, from India, from Great Britain, different parts of Europe. We have people in our audience from Hong Kong, from New Zealand,
that's
all
fascinating. I
over the
mean,
world. And
yeah.
Natalie Armstrong-Matan, she's the true driving force behind it. And Jean Lawler and I are just so happy to be on the team.
Well, that's awesome. I actually have known, first met Natalie some 20 years ago, and had the great opportunity to work with her in my early mediation career when I was training professionals to be mediators. And so it was really nice to be reintroduced to her again, a month or two ago through our shared colleague, Susan Guthrie.
Susan's been a speaker
Yeah.
on the Possibilities Hour, very popular, a lot of great information from Susan.
Yep, absolutely. And so that she's the one that made the connection for, we were already talking about coming on the podcast, and then she made that connection with you being involved too. So it just sounds like an awesome project. And I take it that when people go on to register at the website, then that's where they can make their donation.
Yes, it's Will Work for Food, willworkforfood.news. Willworkforfood.news.
News. Okay. Okay. Very good. Well, Jeff, this has just been absolutely wonderful to have you here with me today, and to address such an important topic around confidentiality in the mediation world, particularly as we go virtual. And the Will Work for Food project is a good example of how we can reach thousands and millions across the world by having these kinds of platforms. And so I find it an exciting time ahead. Of course, raising new issues about how we do business and how we manage our mediation practices. And I want to let our viewers and listeners know, Jeff does have two articles that he is willing to share with you. One is about the conflict of laws, as we've been talking about today, and the other one addresses mediator confidentiality. And so those articles will be available as PDF downloads when our link is released. So, okay. Well, Jeff, thank you again. It's been delightful. And I just want to wrap up here and say a few things again. I hope that our listeners and viewers have learned some new ways of thinking about mindset for people in conflict. My goal is that you gain some insight to shift your own mindset and to open up our ways of thinking about how we've done things in the past and how we'll do things in the future. And so don't forget to subscribe so that you get notified of our next upcoming podcast. And if you enjoyed this, please share it on social media, either on Facebook or LinkedIn. And thank you for being part of the Decoding Conflict Mindset.
Debra, let me add my thanks as well. I would like to thank you for inviting me to be on this wonderful podcast. You have a great podcast series going. I'm so proud to be part of it. Thank you. Thank you to all the listeners. And I believe that if anybody has a question, they deserve an answer. So anybody who would like to reach out to me, my email, easy to remember, it's my initials, JK, at my name, jeffkichaven.com. That's jk@jeffkichaven.com. And I'll even give out my cell phone number. Please remember, I'm in the Pacific time zone, so don't call too early or too late. My cell phone number is 310-721-5785. That's 310-721-5785, or jk@jeffkichaven.com. If anybody has a question or if I can help in any other way. Once again, Debra, thank you so much.
Well, thank you. And thank you for being so generous, Jeff, with your time, your articles, sharing your contact information. So friends, you have it. Reach out to Jeff if you've got some questions about our topic here today. And so I'm Dr. Debra D, the Mindset Doc, and your host of the DCM Podcast. Thank you for joining us. Our next guest speaker is someone you definitely have to mark your calendars for. Introducing to you the Chief Peacekeeper, Scott Levin. Scott is an amazing family law attorney, mediator, now exclusively a mediator, hence the title Chief Peacekeeper. He had a very interesting podcast on my great friend, Susan Guthrie, our diva on online learning to mediate, in that he talked about a very important concept called emotional justice. So many times people think out the legal system in order to achieve what the system's not really designed to do. They're seeking some justice for the emotional pain that they've experienced, particularly when a family is breaking apart. So don't miss out. Listen to the Chief Peacekeeper, Scott Lemon. You won't be disappointed.